Hello YouTube, I'm Vince White. I'm an employment attorney. I'm answering publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. And I believe, well, at least we're posting this video on Christmas Day of 2022. Hence the, wow, I just missed that 3 times. It's hard in the reflection of the camera, all right? That's my excuse. We are answering a question from nvanphoto59. It was posted about 1 day ago. And I will read it into the record right now. Mr. White, my case just got closed. No cause. I guess they had a no probable cause finding. They said I had no evidence and believed the counsel who said they did not discriminate and had no other choice than to fire me. I called downtown and was told I can write to get the decision reconsidered. 8 months in investigation. Are there 5 tips you give me to point out flaws in the final determination? I was thinking that their position statement and rebuttal show their hearsay and pretext. I don't want to go hard trying not to get investigator in trouble, but it looks like the only thing she read was counsel's position statement. Thank you. Okay, so here's my thought. I don't know what state you were in, but I hope, it sounds like you got a determination from a state agency, possibly even New York State. I hope you cross-filed with the Equal Employment Opportunity Commission, because here is what I'm going to say. When you ask an agency to reconsider its finding, it is a tough uphill battle, because what you're doing is you're asking the same people who just decided against you to do extra work and decide they were wrong. The chance of success in that endeavor is very low. Not to be a Scrooge. I'm sorry to give you this answer on Christmas Day. But what I will say is, if you cross-file with the Equal Employment Opportunity Commission, you can just say, hey, thank you for your erroneous determination, state agency. I am going to make a hard pass on accepting that as the final word. I'm going to go to the EEOC and ask them to do their own investigation. Now, likely they will perhaps not do their own investigation. Sometimes they do, sometimes they don't. But more importantly, you'll be able to get what's called a right to sue letter. And your right to sue letter will give you access to federal court for your claims, which is a huge undertaking. And I would absolutely recommend that you obtain counsel for that undertaking, but is much better and much more likely to succeed than to ask the state agency to just reconsider. It almost doesn't, you could have them dead to rights. You could have a spread of evidence that just, with the state agency says, listen, everything in your decision was a lie. It was all nonsense. And be like, we don't agree. You can say, why? Why don't you agree? Because we'd have to say we were wrong and do extra work. And we don't care because we work at a state agency. We can't really be fired. So is that cynical? Yes. Do I like being cynical on Christmas Day? No. But I do want you to be at least on the right path and be engaged in a strategy that has an actual chance of putting up a win for you. So I would tell you, EEOC, get your right to sue letter, go on to federal court. That might be the better path here. I'm sorry, I'm not going to give you tips for the reconsideration letter, just because it can be so difficult. My tip is don't engage in a reconsideration letter. Not necessarily a good use of your time. We occasionally do it for clients where things are so egregious that we just can't stand it. Like we have to keep fighting, and we'll even tell those clients, like, listen, we're going to do the EEOC. We're going to have them take a look at it instead. But we'll do this reconsideration letter. But it's incredibly rare because it's just not really a good use of time. Excuse me, very much. I hope this was helpful. I hope you're all having a wonderful Christmas and that Santa brought you fair pay and equality in the workplace. And like and subscribe. Take care.